Okay, thanks for bearing with us. For those who've actually been looking at the screen and are sort of, our gestures of amazement. We've got a huge screen here, and I've never seen myself in such close profile. So just to welcome everybody. It was billed as a hybrid. We have now got 4 people in the room with us, as well as us, but I suppose the benefits of hybrid are that hopefully we got somebody from Northern Ireland joining us. Owen McCluskey was on the attendance list, and some people from Scotland, from Shelter in Scotland, and some Southwest attendees. So welcome everybody. I've got the great delight of chairing this meeting. I think I might have been billed as speaking, but you're not hearing much from me. We're going to hear first from Tom Royston, who, my phrase, he lives, breathes, eats, sleeps social security law. And sort of in a coffee just briefly beforehand, he was telling me how he's got 3 cases in the Court of Appeal, welfare benefits at the moment, and waiting permission to appeal to the Supreme Court on one of them, and potentially a couple of others going up to the High Court. So Tom is, to me, Mr. Social Security, following in the footsteps of Richard Drabble. And we work closely together at Child Poverty Action Group. And then we've got Adam Straw, who I don't think quite eats, sleeps and breathes social security to the same extent, but wide-ranging practice. Most recently been involved in Shameen Begum case in relation to deprivation of British citizenship, and challenge of refusal under the Afghan relocations and assistance policy to relocate 8 Afghan BBC journalists. The last time I shared a panel with Adam was everybody remote in the middle of the pandemic, and it was in relation to discrimination law. And after that, Adam published Discrimination in Public Law. So I'm wondering whether sharing a platform in relation to welfare benefits will lead to any further publications. We shall see. But we're going to start with Tom.
Hello. I hope that those watching here and around the country have a short handout from me entitled Human-Sized Decision Making. That doesn't set out everything I'm going to say in this talk, which I expect will last about half an hour, but it contains, most importantly, a factual summary of the key cases and policy developments that I'm going to discuss. That handout starts with a quote from Albert Einstein: "Make everything as simple as possible, but not simpler." Happily, I discovered that that quote is a considerable simplification of what Albert Einstein in fact said. And I footnoted what he in fact said, and it's a bit impenetrable. The reason I chose it is because it's a constant message from those responsible for social security policy and administration that simplifying the benefit system is a good and often necessary thing. And nobody could deny that as a matter of principle. But sometimes excessive simplicity makes a system unresponsive to human-sized need and variety. So I wanted to focus by looking at some recent litigation and some forthcoming policy proposals trailed by government at situations where the complaint of the litigant is in essence that the system itself is oversimplified. The first part of my talk is about legislation. I'm going to talk in particular about a case called AT, which was heard by the Upper Tribunal last year and which is awaiting the Court of Appeal's decision. Then about policy challenge, using the example of Timpson, which likewise was heard by the High Court last year and is awaiting a decision from the Court of Appeal. And then about some spring 2023 policy announcements from the government. An advantage of discussing 2 cases that are currently awaiting the Court of Appeal is that you will be able to look in a couple of weeks and see that I was completely wrong about everything that I said, or maybe not, who knows. The case of AT is about the rights of European nationals with pre-settled status, who and that subset of those who find themselves in really, really difficult circumstances. A common subgroup of people with pre-settled status who experience difficulty accessing social security are people with young children who are seeking to escape domestic violence. That's the factual matrix that occurs in a lot of the cases on this topic. When pre-settled status was introduced, it came with full rights to access the benefit system, though it appears the government probably didn't realise that, because a few months after, it made regulations excluding everybody with pre-settled status and only pre-settled status from access to means-tested benefits, so benefits that require what's called a right to reside. The reason that this is an example of excessive simplicity is that, I suggest those regulations were made in a hurry because the government realised that it had accidentally conferred social security rights on a much larger group of people than it anticipated. And perhaps as a result, the government did not take the time, as far as can be seen, to consider whether the nuanced approach to access to benefits that applies for most migrants in the UK should apply here. Where I say nuanced approach, what I mean is that if a person has a right of residence in the UK subject to a restriction that they must not have recourse to public funds, there is a well-worked process for applying to waive that condition. And it's commonly adopted where a person is in such dire straits that they will be at significant risk of injury to their welfare if they don't quickly get access to the benefit system. People with pre-settled status aren't actually subject to the condition of no recourse to public funds. That their immigration status makes them is indistinguishable from that of a person who is allowed access to the benefit system, which is why initially a claimant could have access. But the regulations that exclude them exclude everybody, and there's no hard cases exception. Now, the government makes three main points in defence of its position, because as I won't take you through in detail the facts of AT, which I've set out in the handout, but the upper tribunal, sitting as a three-judge panel of two very experienced social security judges and Mr. Justice Chamberlain, decided that the regulations had to be disapplied because they led to a breach of the fundamental rights of AT because of how bad her living conditions were without access to benefits. The government says three things. Firstly, it's not central government's problem. There are social services operated by local authorities with general but wide-ranging powers to provide assistance to people who need it, and they can satisfy the need for resources to avoid a breach of fundamental rights. Secondly, that the test for a breach of fundamental rights is much higher than the upper tribunal said it was, and that they were wrong to detect that the AT's circumstances, living in a hostel on virtually no money, dependent entirely on day-to-day charity for the survival of her and her small child. They say that that's not a breach of the right to live in dignity. Thirdly, they say that institutionally, it shouldn't be central government that has to work out who the hard cases are. And that's a key argument where government says that a simplistic system is appropriate. That they say that the Secretary of State for Work and Pensions isn't the right person to decide whether a hard case should receive support. Those of you who followed the arguments over the bedroom tax and benefit cap will remember that very, very similar arguments were made in those cases in the Supreme Court about the role of discretionary housing payments, where it was said that their bare availability was an answer to the complaints of discrimination levelled by the claimants in those cases. The focus of the upper tribunal was on the lack of any structured content to the role of the local authority in providing backstop support for hard cases, and also on the simple facts of the case that was in front of it, that AT herself had, with the efforts of a very diligent support worker, made repeated efforts to get help from the local authority. And the local authority had refused to assist her. The Secretary of State's argument was, well, in theory, it's possible to make a claim for judicial review of a refusal to provide support, in that case under the Children Act, and that should have been her approach, rather than to attempt to use the tribunal, the Social Security Tribunal, to get a remedy of access to Social Security benefit. What the Court of Appeal makes of all this, we don't yet know. It's heard the arguments. Judgment is likely to be handed down relatively soon, but of course, until it comes, there's no way of predicting when. The limits to challenges to legislative simplicity, so to when government says, well, we want a system that's easy to administer in its legislative structure, are perhaps quite well illustrated by two parallel cases, one called Johnson and one called Pantellerisco, which I footnoted in footnote 2 to paragraph 3A of the handout. Barristers will always, when giving talks, tell you about all the cases they've won. I've tried to bring myself to talk about some of the cases, many cases I've lost as well. Pantellerisco is one of those. In Johnson, the Court of Appeal decided that the universal credit regulations were irrational in how they calculated earned monthly income. When people got paid on a particular day of the month normally, but it fell on a weekend or the bank holiday, that led to, frankly, crazy results in how the system treated their income, with a person who in fact had a completely regular income being treated as having an income that oscillated wildly from month to month. That succeeded in the High Court, it succeeded in the Court of Appeal. The Secretary of State gave up and changed the law, having said that it would be almost impossible and cost millions of pounds to change the law. They, in fact, did so very quickly. But in Pantellerisco, a similar sort of problem, which in some ways had even more significant effects. The claimant in that case lost thousands of pounds a year because she was paid once every 28 days instead of once every calendar month, due to how earned income interrelated with the benefit cap provisions. That succeeded in the High Court as well, but the Court of Appeal rejected it. I summarise and simplify slightly by saying that the Court of Appeal thought it was mad, but not mad enough to be unlawful. The court fully recognised the hardship caused to an individual claimant, but accepted the Secretary of State's argument that it was just too complicated to facilitate a system where a person paid for weekly, you might think not all that rare or unpredictable a scenario, was not treated as having an income less than she in fact had. You can see Carla recoiling with the trauma of that case. That's one that we lost together. Let me move on to talk about a challenge to simplistic policy, and Adam is going to talk later about a case called K, which maybe is another example of this. Let me tell you about Timson, which is about third-party deductions from benefit to pay for things like fuel and water bills. The law requires, and if you look at page 3, paragraph 11 of the handout, you'll see a reference to the relevant regulations, that deductions be made where it's in a claimant's interests. So you might think, oh, well, that's a handy provision. If somebody wants deductions to be made because it's simpler for their water bill to be paid directly out of their benefit, or even if a person doesn't want it, but a careful analysis of their circumstances shows nevertheless that it's somehow in their interests, this allows for it to be done. In the case of fuel, that might, in theory, prevent disconnection, although disconnection is extremely rare these days. It might also, in theory, prevent having a prepayment meter fitted, although again, that is happily becoming rarer. In the case of water, of course, there's not really very much that a water company can do if a claimant who doesn't have any assets isn't paying their water bill. And you might think, well, how is it in a person's interests to pay off a non-priority debt when the water company isn't allowed to cut them off, isn't allowed to fit a prepayment meter, can't really do very much at all? You might be even more surprised then to learn that the way in which deductions applications are made is that a utility company can apply to the Secretary of State, often on a spreadsheet that may have hundreds or thousands of names on it, every one an individual application, and that the Secretary of State scarcely, if ever, will even contact the claimant to ask them what they think. So how is it in a person, how can you be satisfied that it's in a person's interest to deduct money at quite a high level from their benefit to pay their water bill without knowing anything about what that person says, what other needs they have at the moment, what their general indebtedness is like, what their attitude is to the prospect of court proceedings, and so on and so forth. The High Court found that the approach of not contacting claimants to allow them to make representations was unfair in its legal sense rather than its moral sense. So procedurally unfair, and also that it was what's called Tameside unlawful. That's a reference to a case from the 1970s about the need for rational decision-making to involve investigation in appropriate places. So without talking to a claimant, how do you know anything about their interests? So the court decided that the current policy is unlawfully simplistic. Effectively, what the Secretary of State does in many cases is get a bulk application of thousands of names and rubber stamp them all. That sits with some difficulty with legislation that requires an individual decision, and an individual decision not in the general interest of society, but in the interest of the claimant. The Court of Appeal has heard the Secretary of State's appeal relatively recently against that decision and the declaration that the High Court made, which would require the Secretary of State to change his policy, forgive me. The judgment in that case, because the hearing was only a week or so ago, maybe a couple of months yet, but it shouldn't be too long before we know what the Court of Appeal thinks about all that. What one sees in that case, and also a case called Blundell that Shelter brought a couple of years ago now about third-party deductions to pay court fines, is that the Secretary of State, understandably from his perspective, likes systems where they can process large numbers of decisions with minimal effort. But of course, there's a tension between that and legislation that anticipates individual decision-making. And you might well say that when you're dealing with the incomes of very vulnerable people on very low amounts of money, that individual attention is extremely important. The Court of Appeal is likely to address not only the primary presenting issue of the extent to which discretion has to be exercised on a meaningfully individual basis and informed by positive inquiry of individuals, but also the question of what it means to deduct money in a claimant's interest, though it won't necessarily determine that second issue because it's not directly raised by the appeal. But watch out for that because the conclusions of the Court of Appeal may well be of significance to other challenges to bulk decision-making in the Department of Work and Pensions, but in other government departments as well. Finally, then, the third part of my talk is about policies of the future. The spring 2023 budget statement promised two things related to the social security system. One was increased in-work conditionality. So that's when a person who is doing paid work is nevertheless subjected to the sorts of activities that traditionally would have been inflicted only on an unemployed person. So a requirement to prove that they're looking for work, to be applying for jobs, etc., and that happening at the cost of being sanctioned if a decision maker decides they're not doing a good enough job at it. The second thing that's proposed was trailed as removing the work capability assessment, which on its face seemed very attractive to many people who consider themselves victims of the work capability assessment. As I say in the handout, I think that's a highly misleading, indeed really just wrong description of the policy that's in fact proposed. The work capability assessment is effectively a gateway to who gets to have means tested benefit without having to look for work. At least insofar as ill and disabled people are concerned. You could get rid of the work capability assessment. If you got rid of the work capability assessment, you'd effectively create a form of universal basic income, because you'd say, well, everyone can have this money, and you don't have to do anything for it, you just get it. That, of course, is not what the current government is proposing to do. There will still be a gateway to accessing means tested benefit without having to look for work. They're simply proposing to do it in a much more informal way. So instead of having a formal test for which the government has to gather medical evidence and then assess a person against fixed descriptors, but the notion appears to be that a work coach will decide on whether it's appropriate to impose conditionality or not. Both of these are policies which, in fact, introduce complexity into the system. So if you are applying conditionality to a person, for it to be reasonable, you need to know quite a lot about their circumstances. You need to know what it's reasonable to require of them and what it's productive to require of them. The reason that I include them in this talk about the perils of excessive simplicity is that one can already predict that in those sorts of cases, conditionality may be prescribed in an excessively simplistic way. And the things to look out for as in-work conditionality is extended and the imposition of conditionality departs from a sophisticated legal footing to instead be something imposed on a discretionary case-by-case informal basis. The things to look out for are, in particular, the impacts on people with protected characteristics, because a simplistic approach to who has to engage in work-related activity may well fail to have regard to the specific needs of disabled people, perhaps most obviously, who will have certain things that it's not reasonable to expect them to do, will need certain things reasonably to be done a particular way to enable them to access the provision. And indirectly, frequently for women as well, principally on the uncontroversial basis that women are disproportionately likely to be engaged in caring activities, either for children or disabled people or elderly people, and that may affect, again, the conditionality that it's reasonable to expect them to do, and the nuances of the provision that can helpfully be made for them. So I have indicated right at the end of my handout that things to look for in those proposals make their way into more detailed policy include proper assessment of the equality impact that's anticipated, whether those policies are in substance demonstrating an awareness of the duty, for example, to make reasonable adjustments for the needs of disabled people. And then on an individual basis, whether people, for example, people who are sanctioned, are being unlawfully discriminated against. It's important to remember, when one thinks about conditionality, that although it seems entirely stick from the claimant's perspective, the government's theory is that it's at least as much carrot. So the idea of conditionality is they're giving you useful things to do that will help you, that will benefit you. Now, that may well seem unreal to people who actually experience it, but that's the notional basis of DWP's conditionality programs. So not only may they discriminate against you by sanctioning you for doing something, for failing to do something that it was unreasonable to expect you to do, but it seems to me that people should be attentive to the need to think about making claims that relate to the failure to provide a good thing. So notionally, the government is providing you with helpful support to help you find work. Obviously, a claimant's primary interest may be not being sanctioned for not doing what was demanded of them when they think that's unreasonable. But it's also important to consider when a claimant may wish to say that they should have been provided with positively useful activities, but because the activities weren't sufficiently matched to their needs, they haven't been. So think about the double aspect of discrimination in that context. That's three levels of excessive simplicity analysed: the legislative level, a policy level, and then to some extent at the individual level. As I say, these are issues that are quite live in the higher courts at the moment. So watch out for Timpson and AT in particular. But for now, I shall leave my talk at that. Thank you.
Thank you very much, Tom. So I'm not quite sure whether Tom's perils about excessive simplicity means that he's advocating for excessive complexity or not, but I'll ask that of him later. I should have said at the very beginning that if people have got questions, if they pop them in the Q&As, and they'll be addressed at the very end of this. But moving over to Adam.
Thank you. Thanks very much, Tom, and thanks, Carla, very much for chairing today. I'm going to do a pretty sort of quick canter through a fairly random selection of recent cases and other developments in social security and asylum support law. Hopefully you will have received a pack which includes some notes from me, and I'm going to follow the format and the content of those notes. So I hope that at least means you don't have to pay attention to too much of what I say. The first topic that I'd like to cover is overpayments and waiver. So it's the case that Tom already mentioned of Kay, in which Tom and I represented the claimant, and we were also instructed by the Public Law Project. Emma Vincent Miller in particular led the team there in that case. This was a case about an overpayment of universal credit that was caused by DWP error, of which of course there are many. The claimant Kay was an individual, a single mother who had two disabled sons, one of whom was claiming child and disabled child element of universal credit. He started an apprenticeship, and as a result of that, due to fairly technical reasons, it turned out that Kay should no longer be able to claim the child and disabled child element. She went to the DWP and told them about his change of circumstances, so that he'd started an apprenticeship, and queried whether she was entitled to universal credit, to the child and disabled child element of it. She didn't just do that once, she did it several times, and each time the DWP came back to her and said, yes, you're entitled to it. About a year and a half later, after her having repeatedly gone to them and querying her entitlement, they ultimately came back to her and said, I'm sorry, you weren't entitled to it, you got to pay us back £8,000 out of your pitiful amount of universal credit that she received. So she sought a waiver under the waiver policy. The published waiver policy is called the Benefits Overpayments Recovery Guide, or at least it's contained within that. The waiver was refused by the DWP, and so she judicially reviewed that waiver and sort of challenge it. And the High Court allowed the claim, and it did on various bases. The first of them was about publishing an unpublished policy. So it turned out during the litigation, a couple of weeks before the final hearing, that the DWP had a pretty significant unpublished policy called the Decision Makers Guide to Waiver. It was pretty beneficial for claimants as compared to the published BORG. For example, it had a number of case studies at the end of it, indicating circumstances in which waiver should be granted. And one of them was pretty much indistinguishable from Kay's case. So it was something that could benefit claimants who were wishing to obtain a waiver. And it hadn't been published. And the High Court held that the failure to publish it was unlawful. Now, the result of this part of the claim was that the DWP eventually said, well, okay, we'll publish it in a way in that we will amalgamate it with the BORG. So they didn't actually publish the underlying document, they amalgamated it. Now, in some ways, that was very helpful in that the BORG has been improved by being amalgamated by the unpublished policy. But the BORG doesn't contain everything that was in the Decision Makers Guide to Waiver, so the unpublished one. The DWP has cancelled the unpublished one. And so it says now that everything that you need to know is in the published BORG. However, the court's judgment in Kay analyzes in some detail what was in the unpublished Decision Makers Guide and says essentially that the BORG, the published one, is the same. And it explains in a number of ways how the BORG should operate, which I'll come back to in a moment. And so if you have a case in this area and you want to really rely on the full policy, then it's a good idea to look at the interpretation of the policy in Kay and what they say about the BORG, because to some extent it's a little bit more beneficial than what you actually see in the BORG itself. So the basic point there is have a look at Kay for the full meaning of the policy. So the High Court went on to decide whether the refusal to waive was unlawful in itself, and it decided it was for two reasons, and both of them are potentially of some wider significance. The first reason why the refusal to waive was unlawful was that it was a breach of Kay's legitimate expectation. So the High Court decided that she had a legitimate expectation that she was entitled to the child and disabled child element of universal credit. But the basis for that legitimate expectation was that the DWP had repeatedly made a clear and unambiguous representation that she was entitled to it. And it was significant to the court's finding that Kay had repeatedly asked whether she was entitled and had repeatedly been told that she was. And that was sufficient, the High Court found, for this legitimate expectation to arise. Once you have a legitimate expectation, the next question for the court is it fair to renege on it? So was it fair for the DWP to say, all right, even if you had an expectation, we're not going to honour it? And the High Court decided it wasn't fair in the circumstances of Kay's case. And the main reason for that was that Kay had relied on the expectation to her detriment. And she'd done that in two ways. The first of them is arguably the most useful and broadest part of it, was that she had spent the money in good faith on the understanding that she was entitled to it. And the High Court indicated that that gave her the defence of change of position, which is a technical defence that comes about in restitution claims. But it basically means that someone in good faith spent money on the understanding that she was entitled to it. And that's a pretty broad conclusion, that it's almost inevitable in these circumstances that if the DWP makes a representation of that form, then benefits claimants will spend it on the understanding that they're entitled to it. There was another reason, though, that why it wasn't fair and why the High Court decided that Kay had relied on this to her detriment, which was that Kay could have organised her affairs differently if she had been told that she wasn't entitled to the benefit. So, for example, Kay could have decided that her son would apply for a different apprenticeship, which wouldn't cancel out her entitlement, or her son could apply for universal credit in his own right. and she lost the opportunity to do so as a result of her understanding of what the DWP told her. The second reason why the decision was unlawful was that the High Court found that the DWP had failed to have regard to relevant considerations. And there were a series of relevant considerations that the DWP should have had regard to, but didn't, which included the following four. So firstly, the DWP repeatedly miscalculated the entitlement. Secondly, Kay acted in good faith. Thirdly, she timeously provided all the information required. And fourthly, she similarly took all reasonable steps available to her to clarify her entitlement. And it's interesting that in particular, one of the decision letters by the DWP did begin to engage with those sorts of factors. But the High Court nevertheless decided that the engagement wasn't sufficient. It was inadequate in order for the DWP to show that it had regard to all of those relevant considerations. And again, those are factors that are likely to apply in quite a number of these sorts of cases. So the sort of good faith and repeated miscalculation of benefits. So hopefully that can be of assistance in other cases. As I say, the court's interpretation of the BORG, of the DWP policy, is helpful. In particular, it clarified that public interest is a discrete ground for waiver, even if the claimant doesn't demonstrate that there's financial hardship or impact on welfare. And public interest may arise from, for example, the individual relying on the overpayment to her detriment, the sort of legitimate expectation type of argument, or the fact that there was a DWP error and the claimant acted in good faith. So each of those, the High Court indicates, can amount to a reason for waiver in their own right, and you don't have to go on and show hardship or financial or impact on health and welfare. The final part of the case, which is quite helpful, is about the public sector equality duty. The BORG has been reformulated on a number of occasions, and the High Court found that there was a breach of the public sector equality duty in section 149 of the Equality Act when the DWP reformulated its policy. The High Court found that the defendant, or a public authority more broadly, has a duty to make reasonable inquiries when there's reason to suspect that a policy might have an adverse impact on disabled people. So it's a pretty low threshold. It's reason to suspect. The High Court rejected an argument that one had to show obvious equality impacts. It was sufficient to show reason to suspect adverse impact on disabled people. And in this case, there was that threshold was met. And that was because there was some evidence that disabled claimants were more likely to have deductions of overpayments than other claimants. And there was some evidence to show that the policy may have a more severe impact on those with disabilities than others. And I say some evidence because the evidence was equivocal. There was some going in the other direction, but the High Court held that that didn't matter. This was sufficient to satisfy the pretty low threshold. So that triggered the public sector equality duty, and it was breached because the DWP failed to assess the risk and the extent of the adverse impact and the ways in which such risk might be eliminated. So there was no evidence that it had done that in this case. DWP put forward a general equality analysis it had performed in respect of the deductions policy as a whole, and argued, well, that's sufficient. All we need to do is, because this is a complex system, all we need to do is do a general analysis. And the High Court rejected that argument and held that, no, you need to do a specific analysis in this particular case. So that's the High Court's finding in K. The BORG remains problematic, and it has been improved in a number of respects, but it does remain problematic. For example, there's no evidence yet that the public sector equality duty has actually been complied with. And there's also a sort of broader issue which can arise in a number of other contexts with the BORG, which is the BORG places the burden on the claimant to put forward all information and evidence necessary to found its application. And the Borg says that if the claimant doesn't provide that, although the DWP can request the claimant to provide things, then ultimately the DWP will just make the decision on whatever it has before it. And the problem with that is that there are going to be a large number of disabled claimants who will be unable to meet that burden. They will be unable, for reasons of mental disability in particular, to go away and put forward the very detailed and complicated evidence that's likely to be necessary in order to prove that you need to have a waiver. And in those sorts of cases, you'd have a reasonable adjustment argument. So that those disabled people, claimants, are put at a substantial disadvantage by the policy, and therefore the DWP ought to make reasonable adjustments to that, for example, by going away and exploring for itself the type of evidence and obtaining for itself the type of evidence that there may be. No, that's fine. We're just having a look at some of the questions that have been put in the Q&A. So moving on through my notes, K may be contrasted with the case of MW, an upper tribunal case that was produced relatively recently. In MW, the claimant's adult daughter had moved in with him, and that fact affected his entitlement to employment support allowance. Now, his daughter had told the DWP and the local authority about the change in circumstances, but the claimant himself hadn't personally contacted the DWP and given them the same information. So he didn't directly notify the DWP in the context of his claim. The upper tribunal held that he should have done, following the House of Lords case of Hinchy, and in consequence, the overpayment decision was upheld. So the High Court, the upper tribunal held that the overpayment was lawful. I should note, incidentally, that the upper tribunal upheld an appeal against a civil penalty which had been imposed by the DWP because of the failure to inform the DWP about this. So the upper tribunal held that the evidence before it did not demonstrate that the claimant had no reasonable excuse, and in consequence, the penalty should be cancelled. But perhaps the most interesting aspect of the case is what the upper tribunal said about Hinchy. Hinchy was decided at the time, 2004, I think, or 2005, when everything was analogue. Everything was done on paper, really. And the upper tribunal recognised that it said it's plainly time that the factual circumstances underpinning the decision in Hinchy are considered afresh in light of the digitisation and data sharing that's now rampant within the DWP and indeed other public authorities. So the idea is, well, things have changed massively now, and we can no longer assume that one department isn't going to tell another department about this sort of change of circumstances. It may well be that evidence will show actually data is being shared so much that a different result should be come to in this sort of case. The upper tribunal didn't think that this was the case to determine that issue, and that was probably because there was simply no evidence before it about digitisation and data sharing, the type of evidence it would need. But it did say that this is something that should be looked at in future. And so if you have this sort of case, consider whether you can obtain that sort of evidence to show that actually within the DWP, everyone knows what everyone else is doing. So that's waiver and overpayments. I'm going to move on to the next topic in my notes, which is, and I'll just briefly touch upon this. It's the main reason for mentioning this case is to try and illustrate some of the ways in which Article 14 is applied, the right not to be discriminated against in the European Convention, and how that's applied in these cases. Because the fact is, it's applied in very different ways and really inconsistent ways between different courts. And a difficult judgment is the case of BK. This concerned someone who was granted leave to remain under the destitute domestic violence concession. Now, that type of person, there is a delay before they are given their national insurance number. And as a consequence, there's a delay before they're granted universal credit. And the claimant who fell into that category said, well, this is unfair because other people who make similar sorts of immigration claims, particularly skilled workers and refugees, get their national insurance number straight away as soon as they've been granted leave, and therefore there's no delay in them receiving universal credit. And the High Court rejected that and said, no, this is compatible with Article 14. And the main reasons were as follows. So firstly, the High Court said the process of allocating national insurance numbers doesn't fall within the ambit of another convention right. Now, the problem with that analysis is that, well, that may be so, but the delay in granting universal credit plainly does. There are many other cases which show that it falls within Article 1, Protocol 1, which is the right to respect for property, and Article 8, the right to respect for private life. And so it's a little odd that the High Court focused on the technical aspect of the case and not the substance. The second reason for the High Court's decision was perhaps a little more understandable, and it was that the claimant, so people who have been granted leave under domestic, destitute domestic violence concession, wasn't in an analogous situation to the other groups that she sought to compare herself to. So the groups that she said she was at a disadvantage to. And those other groups were skilled workers and refugees. And the High Court held, well, not in an analogous situation, and therefore that's a second reason why the discrimination has to fail. You have to show that the group you say you are at a disadvantage in comparison to are analogous. So they're similar, and therefore they're comparable. And the High Court said, no, these aren't similar, not comparable. Now, there are distinctions between those groups, so it's not completely difficult to understand that, but it's important to note that there's real contrast between the extent to which the courts consider that an analogous situation is important to establish. So I'll come to a case a little later, a case called BCD, which was very similar sort of groups being compared, and the High Court said they are analogous, and so you can have discrimination between them. And it's really it's difficult to predict really what the court's going to do. I think it's pretty whimsical. The third reason why this was lawful was that the High Court held that the difference in treatment was actually limited, and therefore it's justified. But again, it was focusing on, in saying that there was a limited difference in treatment, it was focusing on the allocation of the national insurance numbers and saying, well, who cares? And not on the fact that actually you're having a deferral in universal credit, which is really important for those people. So again, another important aspect, another dubious aspect about that judgment. The next area I hope to look at is asylum seekers and benefits given to asylum seekers. And now I'm conscious that I've got quite a lot more of my notes to look at, so I'm just going to skip over a couple of the cases in my notes and focus on hopefully the more interesting ones. So the first of those is in paragraph 14 of my notes. It's the case of J.B. brackets Garner, and it's interesting because of how the court approaches policy and how strictly the court approaches policy. So the claimant was an asylum seeker and a potential victim of modern slavery. And she was given temporary accommodation at a hotel on a full board basis. The statutory guidance on modern slavery said that, and it said in clear terms, that any potential victim who was also an asylum seeker would be paid £35 on top of the normal asylum support payment, so a total of £65. This was anomalous because a potential victim of trafficking who's not an asylum seeker, who's in full board accommodation, only gets £35. And everyone seemed to accept that the intention behind all of this was probably that someone who's in full board accommodation should only be, bless you, should only be paid £35 a week. And the £65 was probably an error and inconsistent with that policy interpretation. But the Court of Appeal said, well, that may be so, but the terms of the policy are clear. You get £65. And the Court of Appeal said there is something called an obvious drafting error, which may lead it to go behind the clear terms of a policy. But that was a really high threshold, and it wasn't met here. The fact that everyone seemed to accept that the intention behind it was different wasn't enough. You have to follow the clear terms of the policy. The next case I'd like to look at about asylum seeking is the case of CB, which is in paragraph 16 of my notes. And this was about the level of asylum support. And the High Court found that the Secretary of State had acted unlawfully in setting the level of asylum support under Section 95 of the 1999 Act. The High Court really reiterated from previous authorities that provision, Section 95, imposes two duties on the Secretary of State. The first of them is to pay asylum support at a level which would cover the essential living needs of asylum seekers who are about to become destitute. And in particular, it has to be set at a level to cover a series of specific categories of essential living needs, and those have been set out in the case law. And it also imposes or implies another duty. It's a sort of Tameside duty that Tom was referring to earlier. And that is specifically in this context that there's an ongoing duty to carefully investigate what amount of money is necessary to meet those specific categories of essential living needs. Now, the Secretary of State didn't make a decision in 2022, even though there had been 10.1% inflation in that year. And the High Court said, well, that breaches both of those duties. And the first of them, is basically an abdication of function. So the fact that no decision was made abdicated its duty to pay an asylum seeker at a level necessary to meet the essential living needs. Similarly, it also breached the duty of failure to carefully investigate what amount of money was necessary to pay for those needs, because it hadn't investigated that really at all. So that was a helpful case for asylum support. The next case I referred to is the case of BCD. I won't go into the facts, but really the main point is to say this is a much more helpful case in terms of analogous situations. The two groups of claimants who were being compared in that case were someone with a visitor visa with a no recourse to public fund condition. And they wanted to say that they were discriminated against in comparison to an asylum seeking family. And you might have thought, well, following the previous case, the BK case, those two groups of people aren't in an analogous situation, so you can forget it. But the High Court held that actually they are analogous, even though there are these distinctions between them in terms of the various rules, and there was unlawful discrimination as between them. So the next area I'd like to look at concerns inflation, the 10.1% inflation we had last year. Universal credit and a number of other benefits were increased in April 2023, April of this year, by 10.1%. And the list of those benefits is in footnote 3 to my notes. But there are some anomalies which remain, so some categories which have been excluded and arguably without proper justification. And one example is that the severe disability premium transitional element will only be increased for new claims, or at least that's what appears to be the case from the spring budget. And if that's right, that arguably is a problem. Another area of legislation which is interesting is the cost of living payments legislation that was brought out relatively recently, the Social Security Additional Payments Act 2023, which requires £900 in 3 separate instalments to be paid to those who within a qualifying month receive at least 1p of a number of benefits. Now, the fact that the cost of living payment is limited to those who actually receive those benefits, so actually receive some universal credit or the other type of qualifying benefits, may be unfair. It's arguable that it's a breach of Article 14, for example. And that's because there are certain categories that appear to be excluded, and it's very difficult to see what the justification for the exclusion is. And a few examples of categories that are excluded are people who have had a good reason why they haven't been paid any of the particular benefit in a particular month. For example, people whose income fluctuates month on month, and so in one month they don't get paid anything, or someone whose date of payment of income fluctuates, which means that in the qualifying month they don't get paid anything, or someone whose first payment of a benefit is delayed, and as a result they don't get paid anything in the relevant month. Now, PLP is, among others, is contributing to the Work and Pensions committee report into this, or inquiry into this, which we hope will be produced pretty soon and may support those sorts of arguments that there's simply no justification for exclusion. How much longer do I have?
You got another, I'll be generous, you've got another 5 minutes.
Okay, I don't know if that's generous in which direction, to the delegates or to me. The next area that I wanted to quickly look at is migration to universal credit. And again, this is a very interesting example of how Article 14 is applied in this area. So the case of TP is the most recent case which found that regulations governing migration from legacy benefit to universal credit are unlawful and are incompatible with Article 14 ECHR. And in TP, that was because severely disabled claimants who naturally migrated didn't receive any transitional payments in respect of the loss of enhanced disability premium. So that group of severely disabled claimants wouldn't receive anything in respect of enhanced disability premium. And that was discrimination as against those who were on managed migration, and they did receive payment in respect of that. Now, the facts are a little complicated, but it's really what's really interesting about the case is how Article 14 is applied. So the first point is about status. To show that Article 14 applies, you have to show that you fall within one of the protected statuses. Under the Equality Act, the list is very limited. You've got sex, race, and so on, very small list. Under Article 14, there's an extremely long list of very specific protected statuses, and that's illustrated by the status that arose in this case, which was a severely disabled person who naturally migrates to universal credit, and that is a protected status. The courts considered the intensity of review, and that's often appears, at least on the face of it, to be an important issue in these cases. How intense is the review going to be? How critical or how much deference will the court give to the Secretary of State? And the court said, well, a low intensity of review is appropriate in this context. It's about welfare benefits. But although it said that, in practice, its review was actually pretty stringent. It rejected a number of justifications put forward by the Secretary of State. And a few examples shows the stringency of its review. The first of them was that the Secretary of State argued that the transitional payment scheme would be administratively unfeasible. And that goes back to the point that Tom was making earlier about complexity and the DWP having to avoid that. And the court rejected that on the basis that the DWP hadn't produced evidence to prove that it would be administratively unfeasible. Another justification that the DWP put forward was about cost. So it said that this is going to cost £150 million, and that cost justifies not taking on this point. And the courts again rejected that. And it said that the DWP had not provided sufficient evidence to show what other expenditure would be at risk if that £150 million was engaged here, and why the other area should be prioritised over this one. So again, it was about evidence. The DWP hadn't put forward sufficient evidence, and therefore that justification was rejected. And so it's a pretty useful example, I think, that case of the extent to which the court will be willing to go behind the justifications put forward by the DWP. So because there's only about 1 minute left, I'll just very briefly summarise the remainder of my notes. The next topic was about place of residence, a case called Harrington in the Court of Appeal recently. Pretty useful interpretation of EC regulation 883/2004. That's the one about the coordination of the social security systems. If you have a case about EC issues and social security, it's and that regulation in particular, it's a very useful analysis of that regulation. The next area was about Article 2 and Article 3 of the European Convention on Human Rights. I referred to a case of Dove, but I think the most practical point I wanted to refer to here is that there is a duty within Article 3 of the European Convention that the state is required to provide benefits if that's necessary when there's an imminent risk that the claimant will become destitute and therefore suffer inhuman and degrading treatment. There's another duty within Article 3 to investigate. And that arises when there's an arguable breach of the substantive Article 3 duties. So if it's arguable that there was a failure to provide an asylum seeker who's at risk of becoming destitute with benefits, then there's at least a case to say that there should be an investigation by the Secretary of State into any arguable breach of that. And one reason for raising that is that the investigations by the DWP into its failures in these serious cases, for example, when there's a suicide attempt, are terrible. I mean, up until very recently, they were all behind closed doors. There was no ability whatsoever for a family or the victim to participate. But they have very recently produced very difficult to understand brief summaries of their recommendations, but that's basically it. They still don't publish anything. And I think there's at least a case to be made that their investigation is unlawful and it's incompatible with the investigative duty under Article 3 ECHR. Anyway, there's some more detail about that in my notes. And so I'll bring it to an end there.
Fantastic. Thank you both for your time at keeping. That was incredible. And thank you just for a talk that spans a huge area of both welfare benefits and asylum support. So I've got a very engaged audience, although I can only see 4 people in the room. So I don't know who's out there posting questions, but we're just going to bring them up on the screen here and try and answer them as best we can. Well, I can't get them up on the screen. Bear with me. Okay. So I'm presuming you can see the Q&As your end, but we're going to take them in order. So what's been touched upon, particularly in Adam's talk, is quite a few issues in relation to discrimination. But these ones, the ones Adam's been touching upon, are Article 14 ECHR discrimination, whereas there's a more general question about running within the Equality Act discrimination arguments in the tribunal and the lack of jurisdiction to hear them. And I was wondering whether either of you had any suggestions in terms of practical ways around that, given the difficulties for benefit claimants to go before the county court or to bring JR claims.
You need to bring county court or JR claims.
Yeah.
There's very limited scope for running Equality Act discrimination arguments in the tribunal. In fact, there was an interesting decision of Judge Ward not long ago that decided you can't even run a public law section 149 breach argument in the context of tribunal proceedings. That's an allegation of breach of public sector equality duty. Even if that's not right, then the scope for Equality Act argument is almost either almost or absolutely nil. So you just practically need to find a law centre or contact the Equality and Human Rights Commission to see whether they can assist with funding, or if you're dealing with a issue of general significance such that a test case may be appropriate, contact an organisation like Child Poverty Action Group or Public Law Project that brings those sorts of cases. But beyond that, Michael, you've identified that you've got to bring the claim in the county court or by way of JR.
So unless you can frame it as a Article 14 ECHR discrimination claim, then as Tom said, your opportunities within the tribunal are non-existent, and it's a real problem because, as Tom has identified, the lack of proactive investigation by DWP. So in terms of what reasonable adjustments are needed to be made, what conditionality is appropriate. It's a ripe area for basic Equality Act challenges. Can I take us to a question in the chat potentially for you, Adam? So it's in relation to the number of waiver requests. whether you've got any thoughts on why there are so few waiver requests.
Yes, well, in the case of Kay, Emma produced a statement which put forward all sorts of explanations as to why there are so few waiver requests. And I think the answer is that, well, there are many reasons for it. Some of those reasons, though, are that there is very little, or well, in an ordinary case, there's no guidance given to claimants that they can make a rate waiver, or if so, how they do it. So most claimants aren't aware that they can do it. Another reason is that the threshold is very high, which probably discourages quite a lot of claimants. The process is very difficult to go through. It's normally, I mean, in Kay, for example, the information that was put forward on behalf of the claimant was incredibly detailed and careful, and yet the DWP repeatedly said, you haven't given us enough. And the idea that an individual claimant, particularly one of the many individual claimants who's disabled, is able to do that is pretty fanciful in most cases. And another reason why there are so few waiver requests, or apparently so few waiver requests, is also exemplified what happened in Kay at the start, which is that Kay made waiver requests and they were ignored. The DWP just didn't respond to them at all, and it took, I think, 2 letters before claim until it actually responded and made a decision on them. So those are 3 reasons. There are quite a number of others, but it's, as I'm sure you all know, it's pretty pitiful, the number of waiver requests. Tom may be able to remember the numbers, but it's something like 0.0001% of all overpayments where a waiver is actually granted. It's like 9 out of 500,000 or something like that. Can you remember the actual figures, Tom?
It's something like that. I think we put in our skeleton that if the Secretary of State made 1 waiver decision a day, they would positively decide to waive an overpayment once every 230 years or something. It was some spectacular. If you were trying to demonstrate a system where discretion didn't meaningfully exist, that would be quite a good case study.
The next question from Peter is in relation to requests for deductions of benefit and grants of rents. Do you want to take that one, Tom?
Yes, I'm not sure that I have a feeling from looking at my iPad that the participants can't see or may not be able to see all of the questions, because when I log in, I can only see 4 of them up. So just in case not everybody has them, I'll set out Peter's question. Requests for deductions on ground of rent arrears are routinely agreed by DWP without giving claimants any opportunity to challenge the deduction and continue even when the arrears decline to well under 4 weeks' rent. Is that challengeable? If so, how? I think it may be. The declaration made by the High Court in Timpson relates to utilities, so it doesn't directly affect the way that deductions are made for rent arrears, but the issues are very similar, and it may well be worth litigating the lawfulness of the policy as it relates to housing. One issue that arises with housing that probably wouldn't arise with fuel or water debt, actually, is that I've been told by advisors of situations where the deductions undermine a decision of the court. So if the county court makes a order for possession adjourned on particular terms, or just adjourns proceedings on terms that a person pay rent at a particular rate, you may often then get a deductions application requiring it to be paid at a higher rate. And the way in which the executive can undermine a nuanced decision of a court is I think, a little bit troubling. So, yes, if you have a claimant with a housing-related deduction, and it seems that that's been made unreasonably, well worth looking into. The solicitors acting in Timson are Bindmans, Emma Varley, but any organisation that's doing public law work in social security, I think may be interested in that kind of case.
Can I just, sorry, just wanted to add one thing, which is about the first question. I'm sorry to jump back about it, which was about discrimination claims in the first tier tribunal, which is just watch out for time limits. In that if you are going to be making a claim in the county court or judicial review, the time limits are obviously pretty short there. And it will depend on the facts of your claim, but it may well be that the first tier tribunal isn't considered to be an alternative remedy. So the time limit doesn't start after you finished your tribunal cases, it starts to run at the time of the actual decision. So just be a bit aware of that.
It has been confirmed that people out there can't see all the questions, so apologies for that, because Tom's now got quite a long one to take. Yeah. So this is your question, Simon.
Ah, yes. What do we think of the potential for Article 14 ECHR discrimination challenges for people with pre-settled status subject to domestic violence? Is there unjustified differential treatment? That's a very interesting question, Simon. The way AT has been litigated is that a number of bases have been outlined by AT for defending the decision of the first tier tribunal that she should be entitled to universal credit. And the first of those, and what's been litigated so far, is the issue about fundamental rights and a breach of the Charter. That's what the Court of Appeal is considering. But there are other issues, so discrimination under the Charter, discrimination under the ECHR, and also an issue about the bias of the primary legislation to authorise regulations that exclude people with pre-settled status. Those are all, as it were, parked in the upper tribunal behind AT. So if the Secretary of State succeeds in the arguments about the dignity and the Charter of Fundamental Rights, those other issues are likely to go back to the upper tribunal for determination. In my view, if you have somebody in an AT type situation, you should be running the upper tribunal AT arguments, but also those alternative arguments.
You finished?
I'm done.
Sorry. I wasn't paying attention, was I? Apologies. So next question over to Adam. This is in relation to the MW case.
Yeah, so the MW case that I discussed, and that was the case in which followed Hinchy, about the claimant whose overpayment was upheld. And the question is, for Mark Hall, in MW, was the upper tribunal's decision based on the fact that the claimant themselves did not make the disclosure, rather than the lack of evidence about digitisation? How would advisors obtain evidence in Hinchy or SK cases about digitisation, and should we do an SAR? So the first answer to that is yes, the decision was based on the fact the claimant did not make the disclosure directly to the DWP. And following Hinchy, the upper tribunal said, well, they should have done, and therefore this amounts to an overpayment. The question as to how you'll get that evidence, you'd obviously have to be quite creative about it. But what as with all of these cases, it's best to just try everything available to you. So make subject access requests for the information that you can think of that you might get under subject access. If you're bringing a claim, then seek evidence in pre-action disclosure. So you can do the usual thing of sending a letter or claim and including a load of factual assertions in the letter or claim, and saying to the defendant, if you dispute any of those, you should identify what you dispute and explain why, and you should produce evidence, and you can refer back to MW to say this is obviously a significant issue, and therefore it's within your duty of candour to disclose that evidence. But you know, who knows where that'll get you, and so it's also important to do everything you can to try and obtain the evidence yourself. I mean, expert evidence is one possibility that it's worth at least thinking about. Yeah, so it's likely to be a pretty difficult task, but certainly worth something that's worth trying.
Can I add on the Hinchey point? I know from my own experience, the upper tribunal is extremely keen to hear a case on essentially on Hinchey in the modern world. As Adam said, Hinchey itself is an old House of Lords case, but of course the facts of it are even older. They go back to the 1990s and an entirely paper-based type system, or almost entirely. The upper tribunal decided to hold a 3-judge panel on a Hinchey point in a case where I was instructed for the respondent who'd succeeded in the first tier tribunal about that purported to apply SK, which is the Northern Ireland case that says Hinchey needs some reconsideration in the modern world. The Secretary of State ended up withdrawing his appeal shortly before the hearing was listed. So I think the upper tribunal is actively looking around for another case to address those issues.
Thank you. Another one for you, Tom, which is related to PIP assessment.
So the upper tribunal, the government says that it plans to use the PIP assessment for deciding capability for work. My understanding is that what it's saying is that it will use the PIP assessment as the sole basis for deciding whether a person gets an additional amount on their benefit. So the extra premium that is associated with significant disability. Unless I've misunderstood, they're not suggesting that that will be the only way a person can avoid conditionality. Quite how that's all going to fit together is unclear. Additionally, and something that's had a very modest degree of scrutiny, the most important remaining contributory benefit for working age people is employment and support allowance, because it's the only benefit. You know, JSA only lasts 6 months in its contributory aspect. ESA for people in the support group can go on for your whole life. So if you've paid your national insurance contributions and then you develop a severe illness in your 20s, you can go on getting ESA contrib for the rest of your working life. It's a significant part of the old style contributory benefit system. If they got rid of the work capability assessment, well, what would happen to that? The white paper says we're going to still have something, but it doesn't say what. So I think we just have to wait and see. But to be honest, they've said they've accepted, well, this all needs primary legislation. And they've said, we're not going to even think about primary legislation until after the next election. So there's probably not much point in speculating further.
Apologies, you might be able to hear a phone in the background, which is like in fact mine. And I can't reach it, so I've had it. So I just wanted to alert people to the fact that in the chat, Michael Bates from Central London Law Centre has posted something in relation to the case that they brought, which responds to Simon's question in relation to AT and its read across to Article 14 discrimination challenges for those with PSS who are subject to domestic violence, just to alert people to that. Just conscious of time, there's a couple of questions left, but I think we happy to take another question, Tom, in relation to lack of DWP failing to ask relevant questions and people not necessarily aware of what information they're meant to give.
That's a live question. The specific question for us is about somebody who claimed universal credit since April 2019, but didn't get the carers element from the outset of the claim because they didn't indicate that they were caring for a person, but they were. There are a number of problems with what might be said to be defects in the universal credit claim form. So it doesn't ask questions that are necessary in order to establish entitlement. A 3-judge panel heard an appeal on this issue about backdating, because the universal credit claim form doesn't ask if you want backdating. And if you ask for it later, the Secretary of State says, too late, you can't have it. A 3-judge panel in a case called AM decided last year that the Secretary of State's approach was unlawful. The Secretary of State is currently going to the Court of Appeal. That's likely to be heard later this year. And that may illustrate and explain some of the wider issues about this. But there are certainly a number of areas where the claim form is not picking up all the relevant aspects of a person's entitlement.
So 7:30 on the dot. That's nothing to do with my checking. So I'd just like to say a big thank you to both of our speakers, but also to you, audience. Now, I've been on quite a lot of webinars where it's really interesting discussions and there's no questions that are posted. So the fact that we've had a whole range of questions and I haven't had to fall back on my stock questions or to ask Tom about excessive complexity. So thank you, everybody, for joining us. Good night.